Swayam Prabha. Digital India. Educated India.
Dear students, this week we are going to discuss different portions altogether. That is, first we may start with the economic theories of IP and competition, and then we will go to the interface between intellectual property and competition law. Then in the third part, so we will discuss the US law completely in nature. So, as you know that there are various theories on intellectual property protection as well as the competition law, the whole concept of competition law. As you know that today specifically we are going to discuss why we should protect intellectual property and what are the economic theories propounded by various people. Then what is the ownership rights of intellectual property, as well as the difference between the property rights and intellectual property rights, that means tangible and intangible property rights. Then what is the social value of protecting intellectual property? Then the incentive theory of intellectual property, prospect theory, and ultimately we will merge with the objective of competition law as well, that is the consumer welfare, and ultimately the innovation and competition, and which is going to contribute to the consumer welfare in the market. And you can see that the theoretical argument of protecting intellectual property and competition policy is one and the same. That means, it shares the common objective to protect the markets, protect a competitive market, and ultimately the economic efficiency in the market. Actually, there are a lot of discussions on really intellectual property versus competition law, whether there is any conflict between the two concepts of intellectual property protection and competition law, or whether these whether the competition law prohibits, or whether the competition law is a hindrance to innovation in the market and ultimately leads to the intellectual property protection, whether these are contradictory or whether these are complementary in nature, which we are going to discuss. First, let us come to the property rights. As we know that each and every enterprise earlier owns properties, the property in terms of tangible property, and in the earlier times intangible property is unknown to enterprises, and the property right is always considered as the private right, and bringing the property right to the intellectual property realm is also sometimes we have to discuss the probability and possibility of the property right into the intellectual property rights. So, property rights, the nature of property right, I mean the property right means the private property rights into intellectual property can be seen from the day one. And you can see the economists like this Harold Domstus was of the view, and they argued that the property rights convey the right to benefit or harm oneself or others. So, there is a close relationship between the property rights and the externalities. That means, there is a very probability of possibility in the property right of excluding others. It is a private right and it is not a public right at all. So, the external effects always affect the protection of intellectual property law as well as when compared with the property rights. So, the comparison between the property rights and intellectual property laws to some extent it is synonymous with the protection of private property. So, here you can see that when it comes to the property rights, the ownership is the core substance in protecting property. According to Domstus, so Domstus says that there are three types of ownership, the ownership rights. The ownership rights which we can see is the communal rights, and also we can see private ownership, we can see the state ownership. There is a lot of difference between the rights in communal ownership, private ownership and state ownership. In a communal ownership, a society or a group of people own the rights. So, or the members of the society can exercise the rights in communal ownership. When we compare it with the intellectual property law, one intellectual property rights which I can relate it with communal ownership is the protection of geographical indications. And geographical indications are not owned by a single person or not a private person. It can be only owned by a group of people. So, we can relate it with the community rights, the communal ownership. If you take patent or trademark, it is connected with private ownerships. I would say that all other intellectual property law is connected with private ownerships, not even talking about communal ownership at all, except the protection of geographical indications. When it comes to the private ownership, it implies the whole rights are with a private person and excluding all other people and excluding the whole world. So, the India rights are with the private person. So, private ownership is very strong when we compare in any of the constitutions. And if we look into the United States, the private ownerships are very much prevalent in property rights. And when it comes to the state ownership, the state may exclude others from exercising the rights, the reason of the political reasons or maybe other reasons which we can find out. For example, in the case of state ownership, so definitely the private ownership is not absolute in nature at all in anywhere in the world, as in the case of intellectual property protection as well. It is not an absolute right. The state can always go for compulsory licensing after paying a reasonable royalty. So, the state ownership with regard to state properties, as well as we can say that there is a control of state on intellectual property rights as well. So, the property regimes actually are open, it is opposed to the open access. So, the two groups of scholars or two schools of thought of the scholars, two schools of thought, what they think is that one school thinks that the knowledge should be open and knowledge should be open and available to everybody and rent seeking is not permitted. On the other side, the other school which says that if there is no incentive, for innovation, no incentive for invention, there is nothing is going to generate, because the private people does not have any incentive to innovate at all. So, in the open access you can see that there is no net gain to anybody, rather or nobody is interested in conserving and improving on the existing maybe technologies. So, open access is more open in nature and there is no incentive for innovation. At the same time, if we look into the intellectual property protection nowadays, there are open access softwares which we can find, their further innovation is also available. So, it is open access softwares are not free softwares, their source code is open, that is all, and anybody can innovate it upon and they can own that particular property. So, there is a conflict of interest between open access as well as the proprietary intellectual property rights. So, open access intellectual property rights is open to everybody. At the same time, the closed doors, that is the proprietary intellectual property rights is absolutely the private rights. So, when we look into the crucial legal protection, the nature of legal protection on intellectual property is that it grants exclusive right to the innovator for a limited period of time. So, the incentive for the public is that it is published to the public from the day one, and once the protection period is over, they can further innovate upon the existing as an invention and which will be beneficial to the society at large. So, it means that there is no trade off between actually tangible property and intangible property. The earlier the enterprises in their books, we can see only the tangible property, the value of tangible property. But when it comes to the present in a knowledge economy, the value of intellectual property rights or the value of intangible property is much higher than the tangible property. So, it is much worth than the regular property nowadays. For example, in the case of the famous brand Coca-Cola, there is valued to the extent of the brand value, the total brand value of Coca-Cola is valued more than 60 billion US dollars, and this is nothing but the intellectual property valuation. So, the IP rights are now comes more and more prominent than the property rights. And if we look into the market, the economists always says that the market works on supply and demand theory, and if the supply is less, then the demand increases, and there are a lot of empirical studies to prove this particular theory. So, actually what intellectual property does? The intellectual property actually limits the supply of this particular product or a particular innovation to the market. It is a limited release. So, the supply is restricted so that the proprietor can benefit, or the proprietor can reap maximum benefit from his invention. So, the market always responds to the demand, and the innovator can benefit out of the demand from the market. That may be when it compared to the intellectual property, that may be related with a new invention or a new technology. There may be a high demand for a new technology, and with that particular technology and a high demand, the intellectual property owner, the intellectual property or the innovator can make benefit out of this particular higher demand from the market. So, the consumption need not increase, the consumption may be stable or constant, but the new technologies can make a lot of changes in the market. So, the intellectual property rights. So, the establishment of the property rights, we can see that always connected with externalities, that these externalities may be the demand and supply in the market, or the more efficient use of the market, the more efficient use of technologies which are available. So, the people say that if there is no social value for intellectual property, you need not go for innovations, or intellectual property have a social value, must have a social value. And what is this connectivity between the social value and intellectual property? For example, in the pharmaceutical sector, the giant pharmaceutical companies always go for inventions on new diseases. So, it is a social value, it increases the social welfare. If the companies does not have an incentive to invent new drugs, then there will be no drugs in the market for diseases, especially pandemics. So, the incentive or the social value of intellectual property has to be measured. So, it creates these property rights are actually nothing but informations. If these informations are kept secret, for example, in one category of intellectual property law is trade secret, and trade secret is actually keeping the information secret. The moment it is released to the people, it released to the market, released to anybody, it is no more a trade secret. So, actually the intellectual property protection is an information which is given to the society at large from the day one of filing of the patents. So, there is a difference between physical property and intellectual property. This information which is connected with intellectual property, it can be transferred, or further more innovations can be made by the people once the term of protection is over. So, there are a lot of economic theories which we can find the specific characteristics of property rights and information, and this information connected with tangible property and also the innovation. So, always the valuation depends upon circumstances, what circumstances the intellectual property is used. But the legal concept of property, legal concept of intellectual property is one and the same: to protect innovation, to protect intellectual property, to protect the private rights. So, always the generation of intellectual property gives a return to the inventor in legal protection. So, we can see the any commercial valuation of intellectual property, the value is based on certain theories. The valuation is done on certain specific theories, which is looking into one is the social value. So, we can say that in this social value of intellectual property protection depends upon circumstances and what kind of invention. So, an electronic invention is different from a pharmaceutical invention. A pharmaceutical invention is different from a mechanical invention. So, to what extent it contributes to the social value or social welfare, it depends upon the circumstances of the category of intellectual property protection. So, mostly the intellectual property protection school, intellectual property protection scholars, or those who argue in favor of intellectual property protection, and one argument is the free rider argument. So, this group argues that if there is no protection, there will be a free rider, a free riding in the market, and there is no investment will come for further innovation. So, the justification is actually not self evident, and the empirical evidences are also not prove this exclusively. So, this difficult idea, the difficult idea of overuse or free rider argument is usually creates the tragedy of commons, which the scholars which they argue. So, the free rider argument is in theoretically sometimes it is correct and sometimes it is not correct at all. And second is the scarcity argument. So, the economists like this Arnold Plant, which says that, so it is a peculiarity of property rights in patents or copyrights that they do not arise out of the scarcity of the objects which become appropriated. Rather, no intellectual property rights is the is arising out of a scarcity, rather it is always or mostly it is arising out of the existing innovations. So, it is a continuation of a process of innovation. So, the creation of the statute to protect the intellectual property law is not connected with scarcity. And also you can see that this scarcity argument is only to protect one's own use, that means to protect the intellectual property right owners interest. And mostly the most prevalent theory is the reward theory or the incentive theory. Here also you can see that these exclusive rights the creating out of so the Plant's argument is on the scarcity argument, and it is the rationale of creation of intellectual property relating to the scarcity argument is not always true. So, we can see that we can start from the assumption that, so if there is no future reward, so nobody is going to invest in ideas, nobody is going to invest in innovation, and nobody is ready to the further renovate and further innovate and further release the information to the public, and they are going to keep their innovations with them if there is no prospect of future reward. So, as so we can see that it is a conscious decision of the public authority to create an artificial scarcity in the market through the protection of intellectual property rights, or partly releasing the information to the market by protecting intellectual property law. So, this artificial scarcity created by the public authority is adding an additional value to the market or additional value to the intellectual property protection, because every intellectual property protection is a controlled release to the market of the technologies or the products or if the intellectual property owner does not have the resources to manufacture that particular product, he can license it to somebody, those who can invest in that particular product. So, in the sense that we can see that there is a price mechanism always works along with the production of or the production of any goods or the consumption of information. So, if there is a controlled release of this information to the market, this always these free rider problems can be solved, and that is the prescription of the authority to protect innovation through the prescription of intellectual property rights protection. And then again we can see that the intellectual property creator or the innovator can always appropriate the property by licensing or through the other means of assignment, etc. He can always reap benefits, economic benefits through the protection of intellectual property. So, even we can see that if the incentive theory focuses on considerations of the standalone innovation. So, that means the incentive theory which clearly says that it is an incentive to the innovator for a limited period of time. But if you look at the efficiency created through that particular intellectual property law, in the absence of such creativity, so the inventive or the inventor's effort would not have been made in the first place. So, actually this incentive is recognizes the efforts or the intellectual effort of any individual who creates intellectual property. And also this incentive theory, this incentive is not given to everybody, but only to the first inventor, or now most of the world it is the first filing theory is applicable in the case of all patents or all intellectual property rights. So, it is first come first serve. So, there may be thousands of people or lakhs of people may be innovating on the same product or on the same concept, but the first person who comes to the intellectual property offices with his innovation and he is rewarded. And these we know that in the search process, why the search process, everybody those who are going for innovations, they do a search of the existing innovations and for further innovation. So, this will help because the only incentive given by the authorities, by the governments is to the only the first inventor. So, the getting property right on information, which requires a trade off between the need to encourage innovation and the protection of interest of the consumers. So, always the physical property rights and the instrumentalism of intellectual property is there is the fundamental difference between these two, because the incentive is given to only the first inventor which invents is a new invention or a new inventor or new innovator is only rewarded. And again you can see that if you look into the business assets. So, there is a cost of information, the cost of information which is related to any intellectual property protection. So, this information which you can see that they can commercialize this particular innovation or information, or I would say that every invention is information. These transactions can ultimately lead to the economic benefit, the economic not only the economic benefit of the inventor, but to the society as well. And it creates the larger markets, it creates larger markets and which commercially viable products, innovative products where the consumers are going to be benefited. So, there is high transaction cost actually related to the intellectual property protection. The creation of intellectual property requires investment, it requires a lot of allocation of resources. At the same time, once the intellectual property is produced, there is the transaction cost is also is added to the consumer. So, all intellectual properties are not going to create wealth, and there is a cost allocation and the transaction cost must be adjustable, and ultimately it should benefit the consumer. So, there is an asymmetry in the information as well as the cost analysis in the intellectual property assessment of intellectual property rights or valuation of intellectual property rights. So, the prospect, if you look into the prospect of the incentive theory, so it says that innovation incentive theory. and it is not only an incentive to the inventor or not only incentive to the innovator, but it is a economic stimulus to the innovation. So, economic stimulus to the innovation which ultimately contributes to the economy, which increases the social welfare, which increases the social value of intellectual property rights. But the risk of rent seeking behavior is more pronounced in the case of intellectual property rights than the physical property rights. This is because intellectual property creation and production requires more cost allocation. So, definitely there will be a rent seeking behavior which can be more prevalent in the protection of intellectual property rights. And some of this so they argue that the risk of rent seeking behavior does not question the existence of intellectual property rights, but you can see that this argument for granting property rights on information at an earlier stage of the incentive process. So, definitely the objective is to allow patent holders to coordinate innovative efforts as well as the prospect of future research. That means, the old innovators and they have to further develop and innovate. In between, and this is for inefficiencies or avoiding inefficiencies as well, because if a new innovator which comes out with a solving you can see that a solution to the problem, existing problem, or it can be considered as a further innovation. And here also you can see that. So, the prospect patent places honor and he is always under the threat of duplication of his goods and duplication of his investments. So, the information exchange to the society must be restricted through the protection of intellectual property rights. So, always the initial innovator make this necessary investment for incurring the risk for getting the fruits of his investment as well as the fruits of his innovation, and it should not be appropriated by the competitors. That is why the intellectual property protection is there. At the same time, the prospect theory of patents assumes that the initial inventor is best suited for accelerating the second generation invention as well, because he have the full information on the existing innovation. So, he can go for further innovation or a second generation innovation, and so this is the prospect theory. So, the prospect of an innovator. So, the always in an innovator is considered to be always an innovator if he innovates further. So, if he comes out with the second generation of innovations. So, this hypothesis is it is very difficult to prove empirically unless the studies insist the independence of competition and innovation. So, innovation in the same sector or in the innovation in the same technology have to do the proper empirical research, then only we can see whether the prospect theory is the empirically proved, which we can see that. And if we look into the exclusive right, the justification for the exclusive right, so is simply but nothing but than extra profits to the innovator. So, here the consumers always bear the cost, but the consumers always look into the innovation. The consumer always look into the benefit of the new product, and he is ready to pay an additional cost for that particular innovation, but it should not be, never it can be exploited. The consumer should not be exploited. Then comes the role of competition law. That means, if any kind of intellectual property protection which is going to exploit the market, then the competition law is going to step in for the consumer welfare. For example, the overpricing, and an innovator cannot put his price on a very higher footing and exploit the market and exploit the consumer, and which is not in accordance with the intellectual property protection. The philosophy of intellectual property protection does not allow over exploitation of the market, and then it comes the role of this competition law. So, the assumption of intellectual property rights is granted, the consumers would be benefit from innovation, and that is the concept and philosophy. and if the innovator is going to over exploit the market, then the competition law is going to step in and act against the intellectual property protection. Here comes the interface between intellectual property law and competition law. So, the theory intellectual property focuses more on long term effects, and the competition law is looking into the short term effects of business practices or consumer welfare. So, there must be a parallelism, or there must be a balance between the long term effects of intellectual property protection and the short term effect of this competition law. So, here as I told you, these most of the competition law in the world, whether it is the US competition law, which we are going to see in the next classes, or in the European competition law, which is examining specifically the effects of this intellectual property law protection on innovation as well as the interface with a competition law. This is inevitable because there must be a balancing act between intellectual property protection and the competition, the process of competition in the market. Then only the consumers are going to be benefited, or the consumers are going to be compensated. If there is no competition law, the consumers are not going to be is paid for the anti-competitive practices of these technology owners. So, it is necessary to look into the interface between intellectual property law and competition law. So, the anti-competitive effects are not good for the market. So, this is going to affect the dynamic efficiencies of the market, or the cost benefit is going to be severely affected by the anti-competitive practices of the intellectual property owners. So, if we can see that the competition law always take into account of these commercial practices of innovation markets. So, and one could see that, or one could see that the ultimate goal of intellectual property protection and competition law is one and the same, that is the consumer welfare. And these concepts which we can see that the understandings may be different. For example, the competition law economists they distinguish between the total welfare, and total welfare, that means the consumer welfare as well as the welfare of the society. But at the same time, the alternative standards are evaluating these business practices is the competition law. So, the competition law have always an eye on the business practices of monopolies. Even though the intellectual property rights grants monopoly rights, the competition law have an eye on the activities of the whether it is competitive practices or anti-competitive practices of these monopoly rights granted to some of the enterprises. So, the total welfare measure aggregates the welfare or surplus of different groups in the economy. So, it can be increase the welfare of consumers, increase the welfare of producers, increase the welfare of economy in total. So, here also we can see that the valuation. So, the intellectual property adds value to the society, adds value to the economy, and more importantly add values to the society at large. So, the economic efficiency theory of economists very well work under intellectual property law as well. For example, here you can see that the Caldor and Hicks, which talks about efficiency as the situation is economically efficient and thus increases total welfare when after this situation has occurred. Either both producer and consumer surplus increased, or one of them increased in such a way that it could potentially compensate the loss suffered by the other. So, the efficiency theory may not always work well with the intellectual property protection, and if the practice is economically efficient, if the technology is a superior technology than the existing one, then the consumers may like the product, and ultimately this innovation help the society to increase the efficiency of the market. And these welfare theories always hang around the intellectual property protection as well as the competition law. So, the effect of consumer welfare depends upon the question of how the monopolist is going to behave in a market. If he behave in accordance with the competition law, there is no interference of competition law, but if the IP owner, so if the intellectual property holder is going to behave monopolistically and exploit the market, then the competition law is going to step in. So, here you can see that if an innovation is going to reduce the prices, lower the prices, and need not be always lower the prices, but lower the prices and better the quality, then the product and services are going to enhance the choice of consumers. So, ultimately as I told you that the possibility of raising the issues. So, the cumulative effect of innovation in an economy as well as in economic welfare and the relation with innovation in the market structure is correlated. There is a direct connection between innovation and the market structure, and this monopolistic interference in the market structure is also one of the criteria. So, we can find two types of innovation, one is the standalone innovation and the other one is the cumulative innovation. In the first one, which is referred to the situation where an IP rights will not be used as an input to the another innovation, and mostly standalone innovations are very much prevalent in the market. Second is the cumulative innovation, which refers to the situation where successive innovations build upon earlier innovations, and most of the innovations are on this cumulative innovations theory. So, the cumulative innovation is widely accepted as substantially increase the social value, and also the three different varieties which we can find it. So, either the second innovation could not be invented without the first one, or either the first innovation reduces the cost of achieving the second one, or the innovation accelerates the development of the second by providing new research tools. So, always existing innovation contributes to the society and reducing the cost. So, again the question of social value comes, whether really the innovation is contributing to the society at large, whether it is increasing the social value. So, it is important to find out this incentive mechanism and also the interface between intellectual property and competition law. So, we can very well say that the original design or the objective of intellectual property is to enhance the social welfare and incentivize the innovator. So, in the next class which we are going to see very specifically the tussle between or is there really a tussle between the intellectual property protection and competition law? What is the level of interface, whether this level of interface is good to the society or it is going to increase the economic welfare, to increase the potential of the market, or whether these monopolies should be controlled with intellectual property rights. These are the issues which we are going to discuss in the next class. Thank you.